I have gone on record with the argument that we should think of copyrights not as a form of intellectual property, but as an intellectual privilege. In fact, I wrote a whole book on the topic, titled Intellectual Privilege, Copyright, Common Law, and the Common Good. Why? I think we need a fresh perspective on copyright law. Traditionally, two viewpoints have monopolized debates over copyright policy. One side questions copyright for the same reasons it questions all restraints on freedoms of expression, and it dismisses copyright, like other forms of property, as merely a plaything of political squabbles. The other side regards copyrights as a form of property that, no less than property in the form of houses, cars, and other tangibles, deserves the fullest protection of the law. I offer a third view of copyright, revealing it as a statutory privilege that threatens our natural and constitutional rights. If copyright really were a type of property, most Americans would belong in jail. Most of us routinely and repeatedly violate the plain language of the Copyright Act. In so doing, we run the risk of court-ordered gags, jail time, and damages of up to $150,000 per infringed work. Ignorance or indifference offers no excuse. So far as the law goes, we are all of us guilty, in theory. But that in practice, nobody seriously thinks infringement should be fully enforced demonstrates that copyright is not property and that copyright policy is broken. The founders did not regard copyright as a natural right. Those who originally proposed and ratified the U.S. Constitution did not mean to treat copyrights like natural or common law property rights, but instead like statutory privileges. They kept copyrights short, allowing a maximum term of just 28 years, and they gave copyright holders only a few spare remedies against infringers. Treating copyright like property has encouraged lawmakers to make it too big and too powerful. Since they passed the first Copyright Act in 1790, federal lawmakers have steadily increased copyright's duration, scope, and complexity. The copyright term has gone from a maximum of 28 years to up to 120. The length of the Copyright Act has increased from around 1,000 words to over 100,000. Copyright represents a federal regulation of unoriginal speech. It issues from out of Washington, D.C. into the most intimate corners of our lives, imposing confusing and detailed regulations on how we share information with each other. It bars us from echoing our heroes, such as Martin Luther King, whose speech, "I Have a Dream," remains under copyright to this day. Copyright policy has fallen out of balance. Although courts and commentators often claim that copyright policy strikes a delicate balance between public and private interests, it does not and cannot do so. In practice, a few powerful lobbies shape the law to suit their own ends, leaving the rest of us in the public poorly represented. Copyright doesn't work that well for most creators. Few get damages when they try to defend their rights in court because the Copyright Act withholds statutory damages and attorney's fees from the remedies for infringement of unregistered works. We'll have less need for copyright in coming years, and that's something to celebrate. Both theory and real-world observations confirm that as markets for expressive works grow, the need for copyright shrinks. Just think of how your access to music, books, pictures, computer programs, and movies has increased in recent years. Thanks to continued innovation, we can expect that trend to continue. For all these and other reasons, we would do better to consider copyright a form of intellectual privilege than a form of intellectual property.